Morning. We are back in Senate Judiciary. It's January 13th. We are picking up where we left off yesterday with the confirmation hearing of Mr. Drescher. And yesterday we left off question. I asked a question about some of the cases that Mr. Drescher had recently worked on, and a response was provided. That was the cliffhanger about prosecutorial discretion, which I had some concerns that I wanted to now discuss today. And is that a fair assessment of how we ended yesterday?
That was my understanding.
Okay.
Yes.
And since I know that yesterday we were a bit pressed for time, as you were responding to the question, and I concluded the committee meeting, did you want to? Was there anything else that you wanted to add from that question yesterday?
Yes, and I appreciate the chance to do that. Yesterday's answer to the question about those cases, I appreciate, was very, it was very Mike Drescher centric. I was explaining to you what I did, why I did, and the reasons behind that. What I wanted to emphasize that I failed to emphasize yesterday is that never once did I lose sight of the fact that what was happening to Ms. Ozturk and Mr. Badawi was extraordinarily profound, and that being detained by the executive branch is an extraordinary situation. And throughout the cases of my participation in those cases, I never lost sight of that. I did not do anything to delay the judicial process. I tried to, as I indicated yesterday, make all of the appropriate ethical and factual arguments that were available, and contributed to the resolution of the judicial, well, the trial court resolution of the executive, of its review of the executive action. The cases are on appeal right now, so the cases are not resolved totally. But I wanted to, given the opportunity, acknowledge that what had happened to Ms. Ozturk and Mr. Badawi had profound impacts on them, and I never lost sight of them.
Thank you. So, in terms of prosecutorial discretion, can you share for us, the committee and those folks listening, can you define what prosecutorial discretion is?
Sure. So the term prosecutorial discretion, to me, I consider to focus on the criminal prosecutor's role, and that is as compared to a civil government lawyer's role, where you're frequently responding to a lawsuit that's been filed by somebody else. Discretion comes into play in both contexts, but the term prosecutorial discretion I've always understood to focus on the prosecutor's role itself. So the exercise of a prosecutor, the exercise of discretion that a prosecutor conducts on a regular basis is deciding whether to charge a case, if a case should be charged, what charges should be brought. Once the case is commenced, how to manage the litigation in terms of assessing, continually assessing the quality of the evidence, managing suppression arguments. If evidence is suppressed, what's the right thing to do? On more than one occasion in my career as a criminal prosecutor, I have stood up in court and asked the court to dismiss a prosecution when our view of the evidence changed. And on the one hand, it's unfortunate when a case that we thought was worthy of prosecution in the end, for various reasons, changes. On the other hand, it's some of my proudest moments as a prosecutor is standing up and recognizing when a case should end. If a case is resulted in a conviction, then there's discretion in terms of what sentence to advocate for, whether we should advocate for leniency or a sentence that is more geared towards retribution or deterrence. Discretion comes into play throughout the criminal process. On the civil side, which is the nature of the cases that we were talking about yesterday, there's a lot of discretion that comes into play as well. But it's very different. As a civil AUSA, especially defending a case, and this I think is true in civil litigation, whether it's for the government or not, your obligation to your client who has been sued is to carefully examine the claims that have been brought against your client, both for legal and factual adequacy, explore whether there are responsible, serious legal responses to them that can be made, to advise your client throughout the process, and to do that in a way that manages the costs of litigation as much as you can. So in the context of the cases we were talking about yesterday, as I indicated, both Ms. Osterk and Mr. Madawi had very strong legal teams. They made very strong legal arguments, but there were straight-faced, serious responses to be made, involving, among other things, the role of the federal district court in immigration proceedings generally, what Congress had specified the role for the courts to be. Congress has stood up a separate court system to adjudicate immigration cases, immigration court. It's a court system that AUSAs do not appear in. And Congress has channeled a lot of the issues around immigration law into immigration court and has tried to limit the involvement of the federal district courts. And these are very serious arguments, and federal judges have gone both ways with regard to these arguments. And so I made those arguments. As I indicated yesterday, never knowingly misrepresented a fact and exercised my discretion in that regard, as I understood my duty to be as a government lawyer in that context. If I had been asked to make a frivolous argument, I would have exercised my discretion not to. There are times when lawyers in the civil division in the United States Attorney's Office in different contexts have arguments suggested to them by agency counsel, and we say no, because we don't assess them to be viable arguments, and they shouldn't be. So it's not really on the civil side prosecutorial, but it's still exercising litigation, legal discretion in that way. And so hopefully that's responsive to your question. There's the criminal side and the civil side.
It is, thank you. So I get where you're coming from here, but and I understand that immigration law is, they're trying to keep it at immigration court, but my understanding is there were some fundamental rights issues that were raised in these cases that we were the prosecutor on, and also just to be clear, I'm not trying to relitigate this or anything. But there are some fundamental issues that do concern me. I think yesterday you had described that it would be unfair to conclude that you personally supported policies of the government because you were an advocate of those policies. You also made an analogy to defense attorneys being responsible for their clients' crimes. And I see where you're coming from on that, but in my opinion, there's a distinction in which, as the U.S. attorney, and as you've described, you did have significant power to exercise discretion in a certain way. And in looking at the two cases that were raised yesterday, which are the ones that we know about because of the heightened publicity, the manner in which the discretion was exercised or not exercised is what's giving me concern here. So you have the ability to choose to file a motion or not file a motion based on the facts and circumstances after you review them, right?
Yeah. Yes, it's the answer is yes.
And regarding Ramesa, her attorneys did file a habeas motion, which you opposed, right?
We oppose principally on jurisdictional and technical legal grounds. Yes.
And so I guess my question is, and I'm presuming that you knew that when this case came to you, that the government had acted to begin immigration proceedings in retaliation for her exercising her First Amendment right by writing an op-ed that was critical of the federal government.
The record in the case includes a memo from a State Department official that points to that article as a material factor in its decision to revoke her student visa. And I was aware of that, and that memo is in the court files, in the public file.
And so if you were aware of that, it's problematic to me that you were aware of that and yet did not exercise discretion to when it came to opposing the habeas motion, and also in your opposition to transferring her from Louisiana back to Vermont. You appealed the judge's decision and also asked for a stay of his decision. And I understand that there have to be zealous advocacy for your client. But on the other hand, there is the fact that you were aware that her immigration proceeding had resulted as a form of retaliation because of her exercising the First Amendment right.
So I completely appreciate your concern, and I appreciate you articulating it. I want to emphasize a handful of things in response. One, I never defended the decision to revoke her visa. That was never a position I took. The scope of the department's authority to revoke visas or not is the State Department has a lot of authority when it comes to managing the immigration system, but I never tried to defend its decision to do what it did to Ms. Oster. The arguments that were made in that litigation were about what was the proper role of the federal court generally, whether the case was in the right federal court, if the federal court had a role to play, and what remedies the federal court could provide. And all of those issues were, all of the arguments I made in that regard were serious, ethical, responsible arguments. For example, what happened in the end, or the current status of the case, is that Ms. Oster is released essentially on a form of bail by Judge Sessions. There's a serious question as whether a court has authority to issue that type of release order in that context. I did not argue that, and I did not try to defend the underlying reasons for Ms. Oster's visa revocation. I tried to manage the litigation in federal court so that the court so that the judge would have all of the appropriate arguments to consider. And in the case of Ms. Oster and Mr. Madawi, the court did that and reached the decision it did. So thank you. So again, I appreciate, and as I indicated yesterday, how I think I used the word irregular that a circumstance of that case was. And it was not lost on me at any point in the litigation. And it's my hope that the committee, Senate, the public at large, does not misperceive the role I played in that case as advocating for anybody's visa revocation.
So I hear where you come from, but it is, the argument isn't my perspective, it's not whether or not you supported the initiation of the immigration proceedings, but rather how you responded to the habeas motions, and the fact that it wasn't the immigration proceedings, it was the fact that somebody's liberty was being constrained, they were being tamed, and how you responded when their defense was trying to address those issues. And as we know, it wasn't just Rumesa, it was also, I believe around the same time, it was Mohsen Badawi as well. And I mean, it's obviously different fact patterns, but the same issues that exist in that case as well. And so, do you have any thoughts or perspective that you want to share on the Badawi case as well?
And so both cases reflect an extraordinary change in executive policy. And as your question yesterday pointed out, break things. Things were moving at an incredibly rapid rate, and they were trying to implement a new policy. We're seeing consequences of that policy implementation across the country now in dramatic and unfortunate ways. And whether that policy was legal or not needed to be assessed by the judge. And that judicial review could not happen without lawyers on both sides doing their job for that system to work. I made the analogy yesterday to a criminal defense lawyer, same thing. The system cannot work without lawyers on both sides. I tried to make the case yesterday to not be perceived as necessarily agreeing with the policy I was advocating for. And if lawyers are associated with the policies or positions they've advocated for through the course of their career, it would not be tenable for them to pursue any other type of work, because the nature of litigation, the nature of government litigation frequently deals with extraordinary imbalances of power, managing the authority of the executive, and doing so in an ethical and responsible way.
Thank you. I don't want to monopolize the floor. I saw Senator Ruth had his hand up first.
I take your point about fair litigation, producing case law that will clarify the new state of affairs. I guess I would also point back just yesterday or the day before, 6 or 7 career people at the Department of Justice resigning in protest because the DHA's response to the Minneapolis shooting appears to be directed entirely at the family of the victim. So I'll just note that that is also an option. My question to you is, you called the issues in the Dowie case and the Oster case extraordinarily profound. Said you never lost sight of those issues. I believe that absolutely. But then you said your work contributed to the resolution of the case, which in a certain technical way is true, but it's almost as though you're saying it's almost as though you're taking credit for the result which you opposed.
I am.
That makes sense.
Now, what I'm taking credit for is facilitating judicial review of the challenged government action.
Yeah.
And, whether it's in a criminal case or those habeas cases, we have a lawyer on each side. They're in very different lanes, but they're on the same road. And not to be melodramatic, it's the road to justice. is the road to figure out what the rule of law requires. And in the middle of that road is the court. In the middle lane is the judge. And the judge cannot make that decision without two competent ethical lawyers in those other lanes. And that's the point I was trying to make. And the profundity of the issues, to be sure, what I was trying to make earlier today was the profundity of the impact on Ms. Oster and Mr. Badawi while they were in detention, in a detained state. Obviously cannot be overstated. But the same holds true in criminal cases too, when the criminal defendant's liberty is at stake. The impact on the defendant in the criminal case or the petitioners in the habeas cases could not be more important to those individuals. And as a prosecutor prosecuting criminal cases, or as a civil litigator representing the government in a habeas case, cannot lose sight of that. And I don't believe I ever did. And that was part of what I wanted to sort of amend yesterday's response of my earlier comments today. But profound issues and found it.
Jenna votes.
I have a lot of questions, and I'll only ask a couple of them right now. One of them is a clarifying question, and at the time that you were prosecuting these cases, were either Ms. Oster or Mr. Badawi suing the government, or were they simply fighting to be let out of detention?
Suing is they had filed lawsuits against the government. They were civil lawsuits. Frequently, those types of cases are people describe that as bringing a lawsuit or suing. The nature of their cases were not traditional civil complaints. They were petitions seeking a writ of habeas corpus. It's civil litigation. It's not a traditional type of civil litigation. So some people could call it suing the government. Some people would say they were actually petitioning for a writ. It's sort of a technical legal point. So people could say they're suing.
But at that time, they were not seeking any damages. They were not seeking, I understand that so Mr. Abrego, the gentleman who was accidentally deported to El Salvador, is suing the government. He is seeking damages for the harm done to him.
So they were not doing that.
Okay. They were seeking release from
They
detention.
were seeking different forms of relief, most predominantly release of detention.
Okay. And at the time, as the prosecutor on these cases, you could have declined to take them forward.
No, see, that's a point I was trying to get at in answering the prosecutorial discretion case. The administration had made its decision. The Department of Justice, the U.S. Attorney's Office, had no control over its decision. It was the State Department and the Department of Homeland Security that revoked the immigration status and then took each individual into custody. That was the status quo when the petitions, the lawsuits, when they were filed, and they were challenging that. Neither I nor anyone in my office had done anything to initiate this immigration enforcement action. It was out of our hands completely. And so if we had declined to do anything, the lawsuit would not have gone forward. It would have been dragged out. There would have been a scramble to figure out who's going to represent the United States. We did not have the authority to decline and result and cause them to be released. We were the defendant effectively the defendant in that action. So I appreciate why it feels prosecutorial, because these people were in custody, but they had not been charged with a crime by my office. We can decline to bring a case. We can, like I said earlier, dismiss a case that we've brought, and that can result in somebody being released. But that was not the case in these habeas cases.
As a follow-up to what Senator Ruth brought up, you resigned recently to pursue a potential spot on the bench, but at no point as this was going on did it occur to you that perhaps on moral grounds it might make sense. I'm asking.
No, it did occur. The short answer is it did occur. And reading the headlines about what has happened in very recent days in Minnesota and DC breaks my heart. And it's a tough spot to be in. According to one of the articles I wrote, among the people who are leaving those offices are among the most tenured, most experienced, those presumably with some of the best judgment that can be brought to bear when these discretionary decisions are to be made, and those who might be the most persuasive, with the most gravitas to be a counterbalance when they are being asked or directed to do something that they find distasteful. It is.
Interject. Oh, I'm sorry. You were saying something. Continue. Sorry, but I did want to ask a clarifying question.
It's a and so in deciding whether this is something that I should resign over, I had to consider what would the impact on the case be. And as I indicated a moment ago, it would not have changed the status of Mr. Madawi or Ms. Osterk if I had resigned. It would have caused somebody else to be in the position of having to stand up in court and be the and be the least popular person in the room because you're taking positions that are principled but unpopular. Had I resigned, I don't think it would have solved anything. And I was available to resign if something worse came through the system.
So I just wanted to ask a clarifying question based on the previous question, if that's okay. So it's not the immigration proceeding that is the concern. I acknowledge and I agree that that is something that you did not initiate, but rather it is the habeas motions in both of these cases. And so my question is, did you have the ability to say to the court that the government takes no position on this motion?
I did I have the ability to do that? I certainly could have done that. I think that would have been a breach of my professional responsibilities.
Even after looking at the facts and circumstances that they were based on why they were being held?
Yes, because there were serious legal issues that judges across the country have come down on both sides of it. It is an unsettled area of the law as to what role a federal district court should play in these types of proceedings, and how a person in those situations, persons in that situation, should have their in what forum is their detention to be reviewed. In immigration courts, there is the possibility of seeking release in immigration court. It happens quite regularly. If Ms. Osterk tried to seek release in immigration court and the immigration judge denied it, so it was not a viable option for her. But she had the opportunity to appeal that determination or that denial within the immigration proceedings. There is a system in place that is built for those types of proceedings. Now, but there's also the writ of habeas corpus, which is a very important part of American jurisprudence, which allows a person, generally speaking, to come to court to challenge the legality of his or her detention. And that's what they did. Congress had passed several statutes specifying specifically that in these areas of the law, the district courts shall not have jurisdiction over habeas cases. Whether these cases fell under the rubric of those statutes or not is still unsettled. And it was a serious and legitimate legal argument to make. And as an attorney for the government, it was my duty to do that as ethically and responsibly and as efficiently as I could, to occupy one lane, the other side's attorneys occupied the other, and it resulted in a judicial ruling that that made the determination as to what the status should be.
Thank you. Sorry for interrupting, please.
Do you believe that we have a moral obligation to use positions of power, whatever those positions are, to say no when things are wrong?
Yes.
Did you consider the chilling effect on free speech in prosecuting a student who essentially penned an op-ed or a green card holder who protested in support of Palestine?
So I just want to be clear again. I did not prosecute them. I did not prosecute them.
Okay,
I'll
reframe the question. Did you consider the chilling effect of these cases on free speech?
Yeah.
When a graduate student is essentially having their right to be here, their valid legal student visa revoked for penning an op-ed, or a green card holder is arrested for protesting in support of Palestine?
I did, and I want to be clear that I did not defend the decisions to revoke their immigration status, their visa. I did not defend them. That was not the issue before the court in the cases I made.
What is your view on who our U.S. constitutional protections apply to?
Questions?
The question is what your view is on who is protected by the U.S. and Vermont constitutions.
Part of that touches on legal questions that could very well come before the court. So I want to be careful not to take a position that is going to commit myself to a position that could come before the court. I will tell you in the context of the extent of the United States Constitution's protections, generally speaking, anybody in the United States is subject to the protections of the United States Constitution. There are cases with respect to non-citizens that identify areas where non-citizens don't have the same degree of protection. A case I'm familiar with is non-citizens, it was ruled, did not have the right to make contributions, political contributions, when it was First Amendment right to citizens. There's a Supreme Court case from the 1940s or 50s in which the Supreme Court concluded that it was constitutional. It may have been distasteful, and some of the justices said as much, but it was not unconstitutional for the government at that time to deport non-citizens based upon their political activity, which would be completely offensive to the norms of freedom of speech and association and other fundamental First Amendment rights. But there are some judicially recognized limits with regard to the constitutional protection of non-citizens in the United States. So generally speaking, the Constitution protects everybody, but there are some judicial exceptions.
That case from the 1940s and 50s allowing deportation for political views, you said that was in today's time would be viewed differently.
I can't speak for, I mean, it was, no, if I left you with that impression, I'm sorry. I don't want to.
That's why I'm asking a clarifying question.
I was trying to answer your question by pointing to some areas where the protections afforded by the U.S. Constitution do not extend to non-citizens, where they do extend to citizens. Whether I think that's a good idea or a bad idea, I probably shouldn't get into. I have strong feelings about it, but given the nature of this proceeding, I don't think it would be appropriate to get into.
But generally, free speech, due process, those things are applied.
Yes. Yes.
I have more, but I don't want to monopolize the time right now. So
I saw Senator Madison, you had your hand up.
Oh, yeah. Yesterday you touched upon it a little bit, just about going from the number 2 post to the number 1 post. And I've got a lot of correspondence just about how that came to be. And you said it's in statute. So I'm wondering if you can expand on how you went from the number 2 to the number 1 post.
Sure. So I joined the office in 2002. I served until last week under Republican and Democratic administrations, almost exactly 50-50. I've been on the civil side for a number of years, on the criminal side for a number of years. In September, in the late summer of 2023, President Biden's U.S. Attorney, Nicholas Karras, asked me if I would be willing to be his first assistant United States Attorney. That's the title for the number 2 position in the office. I loved being just a line at USA. Uh, but I've been doing that job for a long time. I considered, I wanted to support U.S. Attorney Karras. Not only was he the leader of the office, I cared about him quite a bit, and I wanted the office to succeed. I thought my experiences over the years would be well used as the number 2 person in the office. And I agreed. And I became the first assistant United States attorney in September of 2023 when U.S. Attorney Karras asked me to. So I ascended, if you will, to that position under the previous administration. When the election went the way it did, U.S. Attorney Karras understandably decided it was time for him to resign effective on January 20th, the inauguration day. Many U.S. attorneys have made the same decision. Some resigned sooner, some waited a little bit longer, but that was to be expected. Simply because I've been in that position since September of 2023, there is a federal statute that's called the Federal Vacancies Reform Act, which says under those circumstances, and it's not specific to U.S. attorneys' offices, it's government-wide, when the leader of an office such as that resigns, the deputy, the first assistant, automatically becomes the acting head of the office. I had nothing to do with that. It happened automatically. But having been the first assistant, it was my responsibility to take on. And I'm proud of the way I managed the office. I'm proud of the way I looked out for my colleagues and the way I managed these habeas cases. I'm proud of representing my office in the public as its leader in any number of forums. I'm proud of the opportunity to have met with victims and victims' families of some horrific crimes on behalf of the office. I'm proud to have worked very closely with the amazing victim advocate within the office to facilitate those meetings. And so that's how I moved into that position and how I try to conduct myself as the head of the office. Knowing that at any time the administration could appoint somebody to be the Attorney General could appoint somebody to be an interim U.S. attorney, or at any time the president could nominate somebody to become a U.S. attorney. On day one, on January 20th, the new administration made appointments in 4 offices around the country. They didn't do that in Vermont, and they never did that while I was in that position. But I was ready for the phone call to come in at any time. And do I miss being in line at USA and defending civil cases and prosecuting criminal cases? I miss that terribly. Being a manager of the office has a completely different set of challenges. It requires knowing about litigating cases, prosecuting cases, defending cases, but it transcends a lot of that in any number of issues, including trying to decide whether I should resign or whether I should step up and do something knowing it was going to be unpopular, but to facilitate the system I swore an oath to protect, and to also keep the office running as well as it was.
No, that's very helpful just from all the correspondence I've got. It puts to rest that it's a federal statutory issue where number 2 becomes number 1. And
like I said, I never pursued it.
Yeah.
I never pursued it politically or otherwise. If the election had gone the other way, or if U.S. Attorney Karras had stuck around, it would not have happened.
Sarah Booth. So less a question and more a commentary on what we're all talking about, which is, in my lifetime, I've never seen a crisis point in America like we're facing. So we have mass agents who are refusing to identify themselves in the streets, picking out not just people who are non-citizens, but in some cases citizens who declare that they are citizens and are taken away anyway. We have the government bent on sending people to third countries, war-torn third countries, unstable countries, just as a way to remove these people without care for what happens to them when they land in those countries. And I think the average American looking at that can only feel as though this is a precursor to something worse. And unfortunately, at the federal level, Congress has neutered itself in terms of any sort of significant response. So the judiciary has become, as I would argue it was during the first presidency of it has become the bulk. And so you described your position as principled but unpopular. And I think, you know, as you describe it, and I believe you're doing so in good faith, I can accept that. But I think what you're seeing in terms of discourse is we need one, and I believe as a people, we are demanding a response judicially to what is happening in terms of the weaponization of the system. So, you know, not just capturing detainees, but deliberately prosecuting people who have angered the president in some way. That has now become standard practice. So I think everyone is looking to the judicial system for help and restraint of that coming wave. Now, as you describe your own participation in it, you're protecting the system by performing your role in principled way, representing your client in a principled way. And I noted before, you said that contributes to the resolution of the issue in court, and Mosin Badawi, for instance, goes free. But I do think that it's understandable that people would focus on the fact that you weren't moving for Badawi, but rather moving for Badawi, not to confess. And I know that oversimplifies, but I think that's the perspective that people are bringing to this is principled but popular enough? Or do we need, you know, several times it's been mentioned that people have refused to participate and left their positions. And I'm not criticizing you for not doing so, and I note that you have now resigned your position. But as an explanatory framework for the reaction to a nomination, it comes from a deep fear of what the federal government purports to do.
So thank you for sharing that and articulating it the way you do. And I completely understand why people have those misgivings. I share many of them. For purposes of why I'm here, what I would want to impress upon the committee and anybody who's listening is that my experience in the past year has reinforced to me personally, and has, I think, demonstrated to the world the importance of what you were touching on, the importance of the judiciary as a protector of rights, as a check on unlawful executive action. And especially at this time, the importance of the judiciary being willing to do that. Now, in some circles, what the executive branch is doing might be very popular, and it might be unpopular for a judge to make that same decision. In Vermont, it's different. But the important thing is to have a judiciary that is prepared to be a counterbalance to the massive power imbalance that exists between the government and the individual. Having experienced that firsthand in this context, I cannot overstate how much I appreciate the need for a judiciary to perform that role. I understand the positions I was advocating because they were adverse to people who had their immigration status revoked for the reasons that are in the public. I appreciate that why people might have misgivings about me because I'm associated with that. What I've tried to articulate is I was doing my duty. Just like if I'm confirmed to be on the court, I intend to do my duty, whether that means it's popular or unpopular. But it would be done with an eye towards being an important counterbalance to many of the inequities you pointed out. One of the questions you asked to Ms. Nolan yesterday. What is the role of the judiciary in the system where you've got such massive power imbalance? And I think that a short answer to that is to be a counterbalance by holding the executive to a very high standard, whether that's holding police or prosecutors to a very high standard, as they should be, or whether it's holding the executive branch or some other part of the state to a very high standard, especially when what they are doing is impacting the rights of liberty or the quality of an individual or a community's world. So, yeah, I've been in the thick of it this past year. And I could have resigned, but I think the result of resignation would have prolonged the predicament of Ms. Osterg and Mr. Valley. And it certainly would have caused more stress to the system. So I tried to do the right thing. I appreciate why people could see it differently. But if anything, I want to impress upon this committee is that this experience has reinforced to me personally, and I think to any of the educated observers, the critical need to have a judiciary and a Vermont Supreme Court in the state context that's going to perform that role.
Chairman Morrison, if you have any questions.
Well, I've got a lot of questions to throw out here. I have a couple actually. I would ask the same question that I asked of the other candidates, as far as some people perceive your lack of state court and so on and so forth insufficient. How would you respond to that?
So I have a handful of responses to that. First one isn't, I think, I can understand why they're concerned, first of all, because of the job I've had for the last 24 years. But I think it overly discounts the formative stage of my career when I was in private practice and the scope of the work I had in private practice, which include 3 jury trials that included my first day appearing in court was in a family court proceeding that was supposed to be sealed, but a reporter was there before then, Judge Scoglin, who asked to open the proceedings. And the first time I examined a witness, it was the TV cameras were rolling and it was in Barrie, and we were representing the state that had recused from a mental health proceeding involving somebody who had actually committed a homicide, who had been involuntarily committed. So I've been in family court. I appeared before an environmental review board. I appeared in front of the public service board. I participated in these 3 appeals to the Vermont Supreme Court, arguing one and reading others. And so I don't want people to think I don't have significant state court specific experience and state agency specific experience. On top of that, when you are in federal court and when you are representing the federal government in federal court in civil cases, especially in personal injury or court cases, it is Vermont law that applies. So on the civil side of my practice in the U.S. Attorney's Office, frequently we were applying state substantive law. And so I'm familiar with the state substantive law with regard to personal injury. And on the criminal side, many of our cases start with state initiated or local initiated prosecutions where state issued search warrants are issued. Sometimes they start with cases that were brought by state's attorney's offices, and we have to assess the quality of those investigations and the state procedure that applies. And so it was necessary to be familiar with that. Third, generally speaking, the rules of procedure between state and civil courts are the same, whether it's civil procedure, criminal procedure, or the rules of evidence. So there's there are a couple of idiosyncratic quirks here and there that are distinctions, but they are overwhelmingly the same. So the process is similar. And in addition, I think there is some precedent for people coming from the U.S. Attorney's Office to the state bench and having, established themselves as preeminent state judges. Helen Tour comes to mind. More recently, Tim Tomasi, he had experience in the Attorney General's office, Judge Tomasi, Judge Doherty, and most recently, Judge Oyan. So in addition to all of that, the Judicial Nominating Board, having taken a very hard look, including as this committee is, to the whole body of my work, assessed that I was still highly qualified for this job, despite the fact that I've been working for the federal government for the last 7 years.
So I'm not quite sure how to phrase this next question. I'm hearing a lot of questions. I'm not really pointing with fingers, but your response to most of these is you're simply doing your job. So are you comfortably morally with how it was handled? And in hindsight, you've done anything different?
I mean, I don't think so. I don't think so. I appreciate the gravity of the questions. I appreciate the gravity of the concerns the chair and other senators have, and members of the public have expressed. I certainly appreciate, as I indicated, the profound impact those cases had on Minnesota's church and Mr. Medallion. But I did not waver from the oath I took. I did not make an unethical argument. I did not knowingly misrepresent any fact. I contributed from the lane I was in to the path to resolution. I was doing my job, even though it was unpopular, and I would, if I were confirmed to be on the Supreme Court, I would do my job in the same way. I would adhere to my oaths. I would make sure individual rights were protected against governmental overreach. I would hold law enforcement and prosecutors' officers, having been one myself, to an extraordinarily high standard. Whether or not that's popular or not, that would be what the job requires. I think the body of my work over the last 30 years, working for an appeals court judge, to handling, being personally involved in at least 25 appeals before the federal or state appeals court, to participating in other preparation of the office's appellate work, to the range of issues I've dealt with when I was in private practice, dispute between subcontractor and the contractor, or a property damage dispute, or a tort suit, or a landlord-tenant dispute. I defended a rural postal carrier in traffic court while I was in AUSA, because she was a postal carrier and was getting a ticket for driving in the middle of the center console, to investigate and bringing Ernest Lama to justice as one of the 2 AUSAs on that case, managing the investigation, with the support of office leadership at that time, to prosecuting the most serious drug and gun and violent offenses. I've tried cases and lost. I know what it's like to lose an argument, to fail to persuade a jury. I know the stress of being a lawyer before before an appellate court, before a trial court. The totality of that experience would be brought to bear in how I would manage myself if I were serving as an associate justice of the Vermont Supreme Court. And I think that position would be the single best use of that experience.
Thank you.
Yeah. Yeah.
So vote, Steve.
What do you see as the role of the Vermont Supreme Court in this moment in time where we have challenged very real threats? I don't want to say challenges. I want to say threats to free speech, due process, separation of powers, government overreach, and they're flowing daily. What do you see the Vermont Supreme Court's role in that?
I'll answer it in two different ways. One is sort of the nuts and bolts of adjudicating cases that come before it. When there are cases before the court where the court has an opportunity to weigh in on the dynamic that we are in the middle of, to approach those cases with certain biases in favor of that are traditions in Vermont, those biases being protecting individual liberties, recognizing the importance of compliance, recognizing the importance of taking care of each other, general values that make Vermont Vermont and have informed the way that the Supreme Court has conducted itself. Every case has to be assessed on its merits, but every case should be approached with an eye towards the equities at stake. So in sort of a nuts and bolts way. In sort of a meta way, the court, as the manager of the court system and as leaders in the legal community, where appropriate, without compromising the court's job as adjudicators of cases, impartial adjudicators of cases that come before it, recognize the problems that we're facing, whether those problems take the form of Vermont specific challenges, such as trying to make sure that criminal defendants have adequate representation, making sure that litigants in other power imbalance situations, such as landlord-tenant disputes, are afforded a fair opportunity to pursue their rights. The court needs to do what it can in that regard, and it needs to recognize the imperfections of the system and not hide away from it. And I think one of the questions you put to Ms. Mullen yesterday described the system as like meant to be unfair or something to that effect. And the court should stand for the aspiration that the system should be fair and to recognize and deal with inequalities that come before. There's only so much a state court can do in this time, given the nature of the federal and state court system, but the state court should speak the truth to what's going on. And the state court should demonstrate by its actions and by its decisions how a judiciary should conduct itself apolitically, with an eye towards protecting individual rights and contributing to the path toward justice, adjudicating, being to probably overuse the analogy to work the traffic lights on the path, the road to justice, so that people get there as efficiently as they can.
So you said this yesterday, and just repeated it, the bench should be apolitical, and I respect that, but human beings, individual members are not apolitical. And I wonder how you manage and acknowledge your own bias, viewpoint, opinions, and privilege in seeking to sit in an apolitical body.
Yeah, so one of the questions I think you put to Paul yesterday, like, what have you learned later in life or something to that effect? It may not have been for me, it may have been for somebody else. So obviously I was thinking about that. And sort of embarrassingly late in life have I come to appreciate the advantages that I took for granted growing up. I was blessed with two parents who emphasized education and a work ethic, who modeled certain ways of conducting themselves and modeled the points of honesty and support. And it was not until I was probably in my early 40s that I began to appreciate that I took for granted. And part of that was because I was being exposed to people that were being prosecuted by my office, who, if they had had a comparable set of situation being brought up, would be fabulously successful in anything they would have wanted to do. But they didn't have those advantages. And it's neither their fault nor mine that there's this disparity, but the fact of it is that the disparity is there. The court should recognize that. And I presume the court system now has implicit bias rate. I haven't asked anybody if it's because the court system. If it's not, it should be. And if I'm on the court, I would advocate strongly for it. I would, if I'm on the court, I would reach out to people who represent the marginalized communities to get their perspective on how things work. I'm thinking the Defender General, for one, and other members of the defense forum. So yeah, I'm hopeful that response.
Can you tell me about a time that you did make a mistake and how you managed that?
Sure. Yeah. The first one that comes immediately to mind was a criminal case I tried, and it resulted in a not guilty verdict. The defendant testified, and when a defendant testifies and is cross-examined, so that's a big part of the case. It's frequently dispositive. I asked the defendant lots of questions that I thought were relevant, and the jury came back with a not guilty verdict. And so the beauty of the not guilty verdict is that you don't know what you did wrong. Maybe we didn't do anything wrong. Maybe it was a case that was destined to be acquitted because there was never enough evidence to prove beyond reasonable doubt, despite we thought there was. But in hindsight, I made lots of mistakes in how I cross-examined the defendant. I made mistakes in how we argued the case to the jury. And the way I handled it was I tried to recognize those mistakes, try to identify those mistakes, and frankly learn from them. Early on in my career and in appeal to the Second Circuit, I was overconfident. I was asked questions that I was not ready to answer about the implications of the particular case. And I still feel the embarrassment and the stress of not being able to answer that question. And there's no better way to learn how to avoid a mistake and suffering the personal endeavors to make a mistake in that context. Those kind of using in mind. But I make, I make mistakes all the time, and I try to acknowledge them when I do, and figure out how to avoid making them.
I'm curious, what your stance is on use of the death penalty.
What's an HB6 meeting? So there is no death penalty in Vermont, which I think is a completely principled position. You may be asking because the past year, the office I just left has instituted, has filed notices to seek the death penalty. In the federal system, that decision is made by the Attorney General. It is not made at the local level. And those notices were filed, and I did not resign. If I thought the death penalty was so abhorrent that it should not have been pursued, I would have resigned. I want to be very careful not to comment on those cases because they're pending, and I don't want to complicate the case for either side in those cases. So I appreciate this is a roundabout way of answering the question that in the right circumstance, in the right rare circumstance, it would not be unreasonable to pursue the death penalty, provided the person on trial has the right resources to defend him or herself, and provided you are I'm satisfied that that person will be put through a fair process. And in Vermont court, I'm confident there will be a fair process.
Any other, but challenging. So I believe your testimony. There's nothing here that I think is disingenuous. I have no reason to believe that at all. And I believe you, and I think that I also recognize that in your previous role, you were under an immense amount of pressure in new and unusual circumstances. And you're under an immense amount of pressure right now as well. At the moment, I still hold concern about decisions that you made in your role while under immense pressure. And based on what I know at the moment, it's my feeling that some of those decisions were adverse to some individuals' fundamental rights. With that being said, in the interest of fairness, I did mention yesterday that we are open to taking witness testimony. I did not want to imply that we will only take witness testimony from people who may be critical of the witnesses. And this also applies to Ms. Nolan, who I suspect is listening. If you or Ms. Nolan have witnesses who have direct experience with you that you would like to have testify, you are welcome to invite them and to let me know and to let our committee assistant know, just as witnesses who may be critical of your nomination have an opportunity to testify, witnesses who have direct experience with you or Ms. Nolan. I just want to make that clear. I don't know if it was clear yet today, but I want this to be a fair and balanced process. And so we will leave this open for about a week. I'm suspecting we will receive requests to testify, and we will hear that testimony. Any documents that we receive will be forwarded to you and Ms. Nolan, depending on who they are relevant to. And you will also have the opportunity to respond and follow up on any testimony that the committee receives. Committee, is there anything, any final comments or questions before we take the break?
The only thing I'll add is that once this committee closes, nominations move to the floor, and then they have to sit for, I believe, 5 days on the calendar. And then there's some discretion about when to pursue them after that, based on making sure everybody's present and other considerations. But the week timeline in here is followed by about a week making it to the floor. And then I have a little bit of latitude in terms of when to actually bring it from it. We'll try to make it as efficient as possible.
Thank you. Mr. Drescher, is there anything final that you'd like to share with us?
I want to say thank you. I appreciate that these positions come up rarely, and I appreciate why The nominations get scrutinized, I make sure. I've been subjected to, judicial authority for the entirety of my career. I know how important it is for that authority to be exercised pragmatically and humanely, and on a principle basis to account for the rights of individuals. And I would pledge that if I confirmed to be on the court, that I would conduct myself in that manner and would abide by the oath and duty. Thank you very much, and I appreciate the opportunity to respond to anything that might come in.
Thank you. Okay. Maybe we will take a break here. We have some bill we'll be taking up here in a few minutes. Let's come back at 10:55.